Navigating the New Normal, Employment Law Issues in the Pandemic to Post-Pandemic Workplace. My name is Kara Shea. I'm a labor and employment attorney here at Butler Snow in our Nashville office. I have a wonderful group of colleagues today that's going to act as a panel to discuss these issues with us. We have Jennifer Hadaway, who's in Baton Rouge. We have Robin Taylor, who's in Jackson, Mississippi. We have Todd Fotopoulos, who's in Memphis, Tennessee, my hometown. And we have David Johnson, who is also here in Nashville. And like all of you guys out there listening to this, we're in various stages today of being at home or in the office. And we've been that way throughout this pandemic, just like you all have and just like your workforces have. But we're happy to see each other today. And while we can't see you guys, we're happy to have you here today. I'm going to give just a few introductory remarks and sort of set the table, and then we're going to get right into our discussion, which I hope will be informative, lively, and interactive. And it's a learning experience for us. We were talking earlier this week about how there's been new guidance on some of our topics this week and yesterday and maybe today that I haven't seen yet. So it's a developing situation, which is exciting and challenging for all of us. So the way we're coming to this, we've done a few of these webinars here at the firm, and the situation's evolving. So for those of you out there who feel like you're totally on top of this and you've got all your protocols lined up and you are the most COVID compliant workplace ever last April or last August or even last November, you probably need to look at your protocols again and make sure they're where they need to be for the current situation. And we are in an evolving situation in terms of the public health status. We call this navigating the new normal. And I think we all agree that nothing magically changed when the calendar changed. We're still in a pandemic world, but there's developments happening now which are going to cause the situation to evolve. And spoiler alert, we're going to talk about the vaccine a lot today. So we're going to have to all be fluid. We're going to have to all be quick on our feet to adapt to these changes. It's not going to all of a sudden turn back the way it was. And I think it's never going to go back exactly the way it was in a lot of workforces and industries. And we'll talk a little bit about that as well. So we've been getting questions from clients. Everybody on this call are employment law counselors and advisors, and we answer these questions for clients every day. And we've compiled a topic list today based on the questions we've been seeing from clients, the questions we have where we want to give information to folks that's accurate. And we're going to do that in a discussion panel style format. It's going to be kind of free flowing. We are looking at questions as they come in, and we got some questions before this. I think a lot of the questions I've seen are going to be covered by the topics. So if your topic hasn't come up yet, be patient because it probably will. If we have time at the end or throughout, we might get to some specific questions. We may not be able to get to everything, but don't feel like you shouldn't send a question. We will know that you sent one, and we definitely can get back to you after the presentation. All of us here can be reached by phone and by email. I think there's a slide that has all of our contact information, so you can feel free to contact any of us with your questions after the presentation. As far as written materials, we are working on compiling some resources for you all that will be ready hopefully by the end of today. It's a situation where what we did is compile all the latest resources like the executive orders and the government websites and the things that we're looking at, and compile that for you as well as an outline of what we talked about today. So this isn't going to be a talking head presentation where we all click slides for you. It's just going to be a discussion, but we will have written materials available after the presentation to be a resource to you. In terms of what we're talking about, I want to let everybody know this is an employment law seminar. So we're coming at this from the perspective of advising employers about workplace issues and how the pandemic intersects with the current evolving employment law. We're not scientists. We don't play scientists on TV. We're just lawyers. So we're not here to really give an update on, for instance, the vaccine development. I will tell you that we have a fantastic webinar coming up on Friday, February 4th, which is not a legal webinar. It's a informational science webinar. Our great friend, Dr. Buddy Creech, is going to be the presenter on that webinar, which is it's Thursday, February 4th from 10 to 11 a.m. Central Time. So sign up and go to that if you want to know all the nitty gritty about what's going on with vaccine development and rollout and all that stuff. We've had Dr. Creech on L&E panels before, and he's always a great resource. So go check him out. And we're planning future webinars. We realize we can't even cover everything today that we need to cover. So we already have another set of topics coming up for the next few weeks. So keep an eye out for that. I think that's everything I need to cover. All right, did I miss anything, guys? This is not legal advice. This is a hypothetical situation. We're in Las Vegas, so what's said on the webinar stays in the webinar. So feel free to send your questions. All right, first question. It's not a big question at all. It's a pretty minor question. Can employers require employees to take the COVID-19 vaccine? Probably nobody's wondered that, but Todd's been thinking about it. So Todd, what do you say?
I have been thinking about it, and thanks for including me in this panel, Kara, and thank you to all of our clients and friends who are attending out there. All of us as lawyers are very accustomed to speaking at conferences and so forth, and no matter how many times I do this by Zoom, I never feel quite comfortable with the process. So I apologize. I certainly do miss the personal interaction from the crowd and being able to answer questions directly. So my apologies for the format that we're faced with, but like you, I'm working from home, and so we'll do the best we can. So we've spent a lot of time, once the vaccines started becoming imminent at the end of 2020, our group had a lot of discussions about, okay, what does that mean from a legal perspective, and what does that mean for employers? Because a lot of healthcare is driven by the employment setting in the U.S. Through healthcare benefits, and a lot of employers like us have been faced with sidelining their personnel and having to stay at home because of fear of contracting the virus. And so, with the rollout of first Pfizer and then Moderna's vaccine, and now Oxford and others coming online shortly, many employers are wondering whether they should encourage or mandate their employees to take the vaccine before coming back to work. And unfortunately, it's not a clear answer at all. It really can be I guess, summarized in 2 words: yes, but. And the but is really important because I think that after we discuss this topic, you may very well conclude, like the majority of our clients have, that it's not wise at this point to mandate a vaccine. But if you do decide to do that and require employees to do that before they come back to work, then you want to be sure that you're not having a one-size-fits-all program, and that you're taking into consideration certain types of employees that may have very legitimate objections, and you want to make sure that you're handling those appropriately. So let's go into that in a little bit more detail. The U.S. government, from a federal standpoint, has grappled with vaccines for a long time. I think we're all pretty accustomed to that issue from the flu and other vaccines, and indeed. Outside the workplace, our children are required to take vaccines to attend most public schools. So that's not a new or novel concept, but this is a new and novel virus, and that's created a lot of problems under the law. Certainly, the science is trying to keep up with the virus, and the law is lagging behind in many respects and trying to keep up and apply antiquated decisions and rules and guidance to an evolving and not fully understood scenario with how this virus works, and also with the efficacy of these vaccines that are coming out. Indeed, these vaccines have come out in historically fast manner, and we're embarking on an ambitious agenda of rolling that out to 70% of our population in order to achieve so-called herd immunity, and that's really creating a lot of challenges. There are a number of federal agencies that look at the vaccine policy issue, as well as state laws and even local laws inside of states. So you can't look at this through one lens, Kara. You really have to look at this through the various agencies that touch on this, including the FDA, the EEOC, which has the majority of responsibility for employment issues, the Department of Labor, as well as OSHA, which has responsibility for governing employers on uh, on issues involving employee safety in the workplace. So you have to look at this issue through all those lenses. And certainly, I feel like our clients and us included are driving off road right now, in uncharted territory, and we're only allowed to look through lenses that have blinders on them, that look at the law from one perspective. So the EEOC, for example, is looking at the law only through its perspective and blinding our clients from what could be coming on either side. Same with the FDA, same with OSHA. You have to look at all this in totality and come up with a conclusion as to whether or not it's best for your employment situation to do this. So what's different about this situation as opposed to, say, the swine flu, which hit the U.S. in 2009, is that the vaccines that have come online now have come online, Kara, through what's known as an emergency use authorization, which is it's a special fast track procedure that the FDA utilizes. And in doing that, the FDA recognizes and balances the interests of getting the vaccine out fast. We have a public health crisis, so we want to get the vaccine out fast with safety. So while it's not a full use authorization, it has gone through extensive vetting, as I'm sure we've all seen on the news. But what's interesting about the emergency use authorization designation for employers is the FDA's rules specifically require that employees be given notice of that and an opportunity to opt out if they don't want to take the vaccine. So keep that in mind, that this is not a scenario where you have a full-fledged vaccine that's been vetted over a number of years. It is an emergency use authorization only, and that creates hurdles and uncertainty for our clients as they're navigating this. If you do decide to mandate a vaccine for employees or for certain categories of employees that may be present, or have more significant exposure risk and that sort of thing, then you do want to take into consideration the EEOC's recently issued guidance that reiterates the fact that if you are going to mandate a vaccine, you have to provide an avenue for lawful objections or concerns, namely those with a disability that may not want to take the vaccine because of their disability that creates an increased risk of side effects, and also for those that have concerns about religious accommodations, and maybe objecting on those grounds. And so these can be really sticky areas for clients to consider. But certainly, if you're going to mandate a vaccine, these are things you want to work into your policy to make sure that employees who do present themselves or present an issue can do that in a way that invites a discussion under Title VII for what accommodation may or may not be needed. Keeping, of course, in mind concerns about confidentiality and so forth, in limiting those that would have access to that information. So these are all complicating layers to the discussion of whether or not one should mandate a vaccine policy to return to work.
Todd, that's great input to get us started. Thank you. I think we're going to get into some more detail on the kind of protocols an employer would need to put into place to make sure that people can raise those objections and have those processed under Title VII and the ADA. But even before we get to that, and Todd, this is for you, but I throw it out to anyone that wants to make a comment. When I'm advising clients right now, I understand clients have different philosophies on this, and I have some that very much want to make a vaccine mandatory, whereas others are being more cautious. But for the clients that really want to do it, I don't feel comfortable telling them that they don't have any exposure here. If somebody, for instance, got sick from the vaccine, right? Or if somebody says their rights are being infringed on in some way. And it's Todd, you're right, it's sort of vague right now how that would all play out. But based on the experimental or authorization and the status of it, if you want to do a vaccine mandate, even if you do it with the objections, I still think you have some potential exposure there. I don't think I could tell a client otherwise, but I'm interested what you guys think about that.
Yeah, I agree completely, Kara, that, this is all so new, and there hasn't been any significant treatment by the courts or any challenges in the courts that clients can rely upon for guidance. But practitioners are certainly concerned about what the plaintiff's bar is going to be thinking about in terms of actions. For example, OSHA does create a pathway potentially for a retaliatory discharge type of claim, and so that's a concern. Likewise, many states, like the state of Tennessee where I live, have whistleblower types of legislation that would create potential pathways to liability, particularly under the emergency use period where we are right now before these vaccines have been fully vetted and approved by the FDA. And so, there is concern among practitioners that one could bring a state law claim under various state whistleblower causes of action, where they allege that because the FDA's emergency use authorization regulation creates the ability to object if an employer mandates that, then that would be used as a theoretical pathway for liability under a whistleblower type action. So the long and short of it is we just don't know. We don't know what possible causes of actions are going to be brought. Certainly, plaintiffs' bar attorneys are looking for avenues, and will be looking for avenues, and it won't be long before we start seeing those ads on TV. I'm certain. So I do think that you're wise in giving that very important caveat to our clients, that even if they do decide that it's better on balance to mandate a vaccine, and certainly there are a lot of policy considerations for why one would reach that conclusion. There is no clear definitive pathway forward that would insulate a client from potential causes of action, whether it's a federal cause of action under OSHA or a state law cause of action as a whistleblower.
Kara, if I could,
yeah, jump in.
If I could chime in very briefly, I would also say, and this is consistent, frankly, with anytime you get into that situation with the EEOC, whether it be under the ADA or under the religious exception in Title VII, when you're talking about a reasonable accommodation, it's a gray area and it's fuzzy, and the nature of the employer is going to be a very important factor for that. And I was speaking recently with someone who is in a hospital setting, and the hospital is requiring a mandatory vaccine, and that makes a lot more sense if you're working in a hospital where patients are who are very susceptible to getting an illness. It makes a lot more sense to have a mandatory vaccine in that kind of context, as opposed to perhaps a context in which the employees are spaced out, they're working, they're on the road a lot, a trucking company or something that may make a lot less sense for that to be mandatory. So I think at the end of the day, everything is going to be very fact specific. Clients are going to want clear answers from their lawyers, and we're unfortunately not going to be able to give a clear answer, but we can give some advice. And
if you call David, he'll give you
yeah.
a clear answer.
No promises. No promise.
But yeah, we're speaking to. I looked at the registration list. We're speaking to almost every kind of industry you can imagine, and it's going to be really different assessing your risk and formulating your strategy depending on which industry you're in. I'll also highlight something Todd said about state law. There are some states where there are proposed legislation or amendments to current legislation or laws underway that would prohibit a mandatory vaccine. So be aware of what's going on in your local jurisdiction. Also, the practical impact. And I talked to a client about this the other day. We haven't made the vaccine mandatory. We haven't put a heavy hand on it because we feel like we have a lot of people in our workforce that are going to refuse to take it. And this was actually in a home care, healthcare provider setting. And they were worried that if they put a mandate on people, people would just refuse and they would leave. And that would be highly detrimental to that particular client. And plus, it's the very people that have been out there on the front lines putting themselves at risk for all these months. Do you really want to make those people get a vaccine that they're not comfortable with? There's a lot that goes into this. But there also, as Todd mentioned, are some considerations that you have to keep in mind pursuant to the Eeoc guidance and the federal laws prohibiting discrimination. And there are some other issues to consider if you're going to do a mandatory or quasi-mandatory vaccine program, considerations to keep in mind. And Jen, I think you're going to tell us a little bit more about that.
I am. And yes, there are lots of legal considerations to keep in mind, and some of which Todd touched on, so we don't need to harp on it. But I do want to drill down a little bit on the two main objections that you're probably going to get from an employee beyond the emergency use phase. If you decide to implement a vaccine, if we get a little bit more comfortable that we can have that mandatory vaccine in place, there's still going to be two large groups of individuals who would have an objection to it and a right to not participate in the vaccination policy. The first one would be anybody with a disability under the Americans with Disability Act that comes to you and says, I object to having this vaccine because it could pose a threat to me. It could harm my health. It could, exacerbate a disability that I already have. An employer has to, at that point, then determine whether a reasonable accommodation could be made to reduce the direct threat that employee who's not vaccinated may have in their workplace. If the direct threat, and David mentioned earlier, it's an individual assessment. It's how many employees are in the workplace, how close are they, what's the proximity, what's the percentage of employees who've been vaccinated who have already had the disease, are we still in sort of the antibody phase? There's a lot of assessment that needs to go on, so that's going to be really sticky for employers. But if that direct threat cannot be reduced to an acceptable level, the EEOC says that you can exclude those employees from your workplace, but the process doesn't end there. At that point, you then have to decide in the interactive dialogue with the employee, are there other ways we can reasonably accommodate this employee who's unwilling to take the vaccine because of a disability? For instance, could they work from home? Could they continue to work from home? Could they have a private office space? All of the normal things you have to do when you have a reasonable accommodation analysis. Todd also mentioned Title VII. That is another group of people who are protected by, in a protected category of religion. And so if an employee comes to an employer and says, you've enacted this policy, but I have a sincerely held religious practice or belief, that employee may be protected by Title VII. And an employer may need to, will need to then at that point determine whether they're protected and have a conversation with that employee about, again, whether a reasonable accommodation can be afforded to this employee. Those are complex conversations to have. And we'll talk about that as sort of one of the practical reasons why an employer may or may not want to have a mandatory policy at some point in the future. But whether you have a mandatory or a voluntary vaccine policy, you need to be careful about record keeping and questions that are associated with those programs. So for instance, if you're an employer and you want to implement your own vaccine policy, or you want to engage with a third party and have them contracted to come in, you need to be careful not to violate GINO, which is the Genetic Information Act for employees. It protects certain information. Certain questions that medical providers are going to ask the employee prior to giving them a vaccine could elicit genetic information. It could also elicit information which would reveal a disability. So employers should stay away from implementing those policies where they themselves are integrated into the administration of it unless it's voluntary, because at that point the questions are voluntary and the employee is voluntarily giving that information. Now, the information that they'll give you is still considered confidential, and it should be treated as such under the ADA. We talked about sort of OSHA Act sort of broadly permits
And what if I don't like vaccines because I think they're dangerous?
So that's a good point. That doesn't protect, the Title VII doesn't protect anti-vaxxers or people who are scared of vaccinations or who have a general feeling against vaccinations or who have a general, animus against this particular vaccination because the way it was rolled out. It only protects employees who have a sincerely held religious belief. And so that is a really good question. And that leads you to a main concern that most employers are going to have is, okay, it would be great if my entire workforce was vaccinated. I really want it. It would be great to tell the public, you're safe here, come in. All of that would be great. But you have to manage it against the administrative concerns that you're going to have outside of just regular legal implications. For instance, like your managers and supervisors are going to need to know how to communicate that policy. So if an employee comes to them and says, I'm anti-vax, I don't want it, an employer, a manager, a supervisor is going to need to know, how do I respond to that? What is our policy? They're going to need to understand what a request for a disability accommodation looks like. Employees don't often walk up to you and say, I'm making a request for accommodation under Title VII. It's usually a little bit more subtle, a little bit more murkier than that. So those frontline supervisors or managers, the people who are implementing the policy, are going to need to understand the policy, be able to communicate it, or at least know who to direct the questions to, which leads you to the fact that you probably need well-trained HR staff or to engage counsel or your general counsel, because that interactive process that we engage in all the time for employees with disabilities is difficult enough. It's sticky enough, like Todd said. But in this age of remote work and unusual circumstances and requests based on religious reasons, all of that is sort of not the regular run-of-the-mill disability request. So your HR staff, your general counsel is going to really need to understand how to do the analysis, how to consider the accommodations that we need to make. And again, like David said, a lot of it's going to, each one is an individualized assessment. Communication, we've already talked about. Records, we've talked about. It's important for your managers and your supervisors to understand that if one employee opts out because of a disability from the vaccine program, that can't be shared with other employees who may be dissatisfied that they had to participate and that employee didn't. So they need to understand the parameters around communication of sensitive ADA information. And again, I think this is just one of those questions where even if we get down the road past emergency use, it's not a question of maybe can we, it's maybe a question of should we for an employer. And what are you going to do if a large swath of your workforce rejects it, which I think practically a lot of us are seeing our clients, especially our healthcare clients, are not having as high of a participation rate in the voluntary program as they thought they would. So I think it could have significant ramifications on retention and recruitment of employees in an already difficult time.
It's so hard because then you have the segment of the workforce that wants to be as safe as possible and feel like everyone around them has been vaccinated. So it's such a dilemma. And we had a great question come in that I do want to touch on before I put things back in Todd's court. If a mandatory and an employee has a reaction or incident related to the vaccine, would that pose a workers' compensation risk? With the caveat that workers' compensation law is state specific, and I don't know all the laws of all 50 states, I think, yeah. I think if you're requiring somebody to get a vaccination to be employed for you, you can very well expect that to be covered by workers' comp. That hasn't been fought out yet, but I would say, yeah, that you should you should consider that a possibility. Do you guys feel any different?
I don't think differently, Kira. I will say that in that context, as well as in other contexts, such as somebody claiming they got COVID in the workplace, often it's difficult to pinpoint where the symptoms arose. And so it may not be clear cut that the person's symptoms are related to the vaccine as opposed to something else.
That's for your comp carrier to figure out.
That's for the comp carrier to deal with. It certainly could be a comp claim that, in pretty much every state.
But if it's not covered by workers' comp, then maybe they'll sue you, outside of workers' comp for making them get a vaccine that made them very ill. And that goes to the concern I raised initially about, I think that's a different calculus if it's a voluntary vaccine that they're going to get on their own, that you've encouraged them to get, versus something where you say, you got to get this shot and show me proof or you can't work here anymore. If I'm a plaintiff's tort lawyer, that would make a big difference to me. And if I was an employer, I'd almost rather have the workers' comp cover it. But,
well, you're probably right. I think at the end of the day, you hand it over to your carrier and let the carrier handle it.
That's what insurance is for.
Right.
Right. So let's say we've decided we're not doing a mandatory program right now. Is there anything we can do to encourage or incentivize people to take the vaccine? And if so, what do we need to be thinking about? Todd, what do you think about that?
That's a great question, Kara. And we're starting to see a lot of that proliferate in the marketplace. I think Dollar General was one of the first companies to publicly come out and adopt a policy where they were going to provide an incentive program by paying individuals who chose to get the vaccine 4 hours of time at their regular rate. Other retailers and employers are starting to follow suit with that. I've seen that the retail or the grocery chain Aldi, as well as Trader Joe's here in the U.S. are adopting similar plans to allow for incentive-based, not a mandatory process for vaccines, but an incentive-based program to encourage employees to take the vaccine. So, and we've seen those in a variety of ways in terms of whether it's going to be a few hours of pay to remove a barrier, as Dollar General put it, so that hourly workers wouldn't feel discouraged from taking time off from work to go get the vaccine, to PTO, adding PTO to the bank, to gift certificates, or a combination thereof. So we're seeing a number of clients getting away from the idea of a mandatory vaccine for the reasons that Jen was just describing, and Carrie, you were also reinforcing, and going to this more of a voluntary process with an incentive.
Carrie, a few things I heard there, like if you're in, if you're giving some sort of prizes, or just remember the tax consequences. Remember that it could be considered compensation under FLSA or under state law. And if it's voluntary, but there's a formal incentive program that people are encouraged to do, keep in mind also the issue of whether them going to do that is work time or could be considered on duty for workers' comp purposes. So just a few things I thought about. I think that it's still a good thing to do, but you want to keep in mind the ramifications of it, depending on what your is.
And a couple of quick points there, Kara, if I could. Three quick things. First of all, keep in mind that the EEOC hasn't fully weighed in on how this is going to play out. Are incentives like this considered a wellness program under the ADA? And if so, then you would be falling within those requirements. And indeed, the EEOC has a proposed rule out that's trying to address some of those issues, but that's very much unsettled. The big implication there would be, what type of award could you give? And the EEOC gravitates on the wellness program side to more de minimis type rewards, and so that could further constrain employers who are trying to do the right thing. And indeed, does fall into the bucket of no good deed goes unpunished. You also have to tease out the disability issue and then the religiously held belief issue that Jen was touching on in her piece of the program. So, the question would be is what if someone has a disability that or presents themselves to the employer and says, I have a disability, I can't get the vaccine because I have a high allergy rate to this ingredient in the vaccine. Nonetheless, I would still like to participate in this program. And so how do you accommodate that person? And I think that if you do provide some sort of a wellness type incentive or a vaccine incentive, you have to take that into account, as well as people who have religious objections. And so does the employer come up with a different avenue for those individuals to earn the incentive, attend some sort of a program, for example, on safety issues related to the vaccine and that sort of thing. So these are issues that an employer really has to tease through. It's not just a quick, simple answer.
Yeah, I'm hearing that we're pro incentive programs, but it's highly recommended that you get those vetted by someone who is conversant on these issues, your general counsel, your outside employment counsel. Switching gears a little bit. So we're in the situation where the vaccine is available, and so everything's fine, and the workplace is totally safe, and we can quit doing all that annoying stuff we've been doing for the last 10 months. Right, Robin?
So not quite. Just to revisit what Todd was talking about, I think one thing for employers to keep in mind is that even if they're inclined to mandate vaccines, they can take a measured approach. They could begin with training and assess who is being vaccinated, and then do an incentive program and assess who's being vaccinated. And then at that point, later on down the line, if it's necessary, then look at the mandatory vaccines. But it's, I think probably from an employee morale piece, it would probably be very, very difficult for a workforce to immediately go from, no vaccine to that being required in the workplace. So now we're going to move forward. Where hopefully we're all getting vaccines and it's a little bit safer to go around. I know I have not yet gotten a vaccine. I know my mother has, who is 75 years old, and she got it last weekend. And I told her, now don't go crazy and go to the grocery store, because she has been ordering her food online and going and picking it up and being very, very careful. Unfortunately, that's the guidance for employers as well. So don't go crazy and go to the grocery store. We have to continue to follow all of our guidelines that the CDC and OSHA has put out. Really, when it comes to the employer's duty to keep a workplace safe, we're going to start with that general duties clause with OSHA. And then employees are going to still have to do the same things, even though they are currently being vaccinated or have been vaccinated. We'll need to continue to wear masks. We'll need to continue to social distance and wash our hands. It's likely that employers will continue to have to do screening mechanisms. Now, as Kara said earlier, this is a moving it's an evolving area. So what the guidance is today, given our numbers in our community and the number of individuals who have been able to be vaccinated, may not be what the guidance is in 18 months or 12 months from now. But where we are now, we have to continue to use all of those measured approaches in order not to become infected. Now, one thing, as we're touching on OSHA, one thing to keep in mind is OSHA, throughout all of this process, has not issued any rules related to COVID specifically. And so the rule that regulates or administers what employers do in the workplace really is that general duties clause. With a new administration, President Biden did sign an executive order last week that gave OSHA a very short period of time to issue more guidance on employers in the workplace, and importantly, an emergency rule, which would create temporary standards for COVID. Now, we don't know what those are. I think we're 6 days into a 2-week timeline. But please be aware that that's going to be coming out very soon. There is a lot of speculation on what that temporary COVID rule would be and what the guidance that's specific to COVID would be. Some think that it could be in line with a mask mandate, although that could be problematic with OSHA's prior stances on masks. But expect for that to be rolling out hopefully within the next week.
Okay. And I think something you said really resonated with me. I mean, we're in an evolving situation. And while we all kind of have been talking to our clients about what the rules are, the fact is it's not really that black and white. What we want to do is keep our clients legally protected in case they're questioned about the safety of the work environment, right? And so if they're questioned about the safety of the work environment, an employee complains or there's an OSHA investigation, we want you to be in a good position. And the best way to be in a good position, absent express guidance from OSHA, is to follow the other guidance that's out there, right? And so the main guidance is the CDC guidance, which we all look at religiously to see what they're saying. And the CDC guidance changes. And the whole reason we get to do a lot of the screening that we're doing and ask all these intrusive health questions is because the CDC has said we're in a pandemic. And we're still in a pandemic, but we may not be in a pandemic 6 months from now, according to the CDC, which means maybe we have to ramp down some of these intrusive safety measures. So it's an evolving situation, and maybe some new OSHA guidance will make it crystal clear, but maybe not. But then there's also the fact that many folks are under state and local mandates about masks and about other things. And that is the law that you do have to follow if that's what it says in your jurisdiction. It's a lot to keep track of, I know. Speaking of that issue of doing those intrusive screenings, asking people their health status, now that there's a vaccine, do we still have to do that? Are we still allowed to do that? David, what do you think?
Yeah, so this is actually a question which I think there is a pretty clear answer to. And the answer to that is yes, it's perfectly fine to continue to do screenings. And Kara touched upon this a bit. But I think we're at a time this year, the past 10 months, where we have seen more leeway from the EEOC than we've ever seen in terms of being able to do things that you ordinarily would not be able to do. And the reason for that is that the EEOC has fully acknowledged that we're in a pandemic, that things are not normal, that things that would not be permitted ordinarily are permitted now because of the situation we're in globally, and that public health, frankly, trumps some of these individual employee rights concerns that the EEOC is charged with protecting. So the EEOC has been very clear that that during a pandemic, health screenings are acceptable. That that guidance has not changed, but as Kara suggested, we certainly can anticipate that guidance changing when the pandemic is over. I'm not sure exactly, that's going to be a date certain in terms of whether Dr. Fauci or somebody else officially declares that the pandemic is over. But I think at some point, this year, knock on wood, we will be getting some kind of notification from the EEOC that its previous guidance is being altered in this respect. But in the meantime, health screenings are okay, will continue to be okay. And what the EEOC guidance essentially says for all intents and purposes. And by the way, if you are in HR, I would very much recommend that you take a look at the EEOC guidance on this. And I think that's part of the material links that we're going to be providing, Kara. It is great. And there are some great Q&As as part of that guidance. But if I could summarize the EEOC's position on this in one or two sentences, it would basically say that screening and questions related to COVID are okay if the employer has a reasonable basis to ask the questions and to conduct the screening. So it's kind of a good faith, reasonable standard. Again, that's a bit gray, but nonetheless, the EEOC is giving quite a bit of leeway. And just one other quick reminder on this topic is to always remember that the ADA requires that individual employee health information be kept in separate files, so that to the extent that screening is showing certain information, don't include that in personnel files. Make sure that's kept separately such that the ADA is not violated.
Thank you, David. And I don't know if this will come to pass, but remember back when all this first started, remember it was about this time last year we started hearing about COVID, and then we really started hearing about it in February, and then we really started hearing about it in early March, but it was a New York thing, you know, and the EEOC's early guidance was, remember, it was before this COVID specific guidance came out. It was, these screenings are okay if the public health situation in your area is a pandemic. And it's possible that our pandemic could phase out the way it phased in. In other words, it won't be national pandemic over day. It will be by state or by region. So just keep your eye on all those bases. And the other thing is, it's not too late. For those of you out there who never really did implement a health screening process for people coming into your work sites, it is not too late to do that. We're in for some more months of this. So if you haven't done it, you should go ahead and do it. And particularly because I think that situation, the need for the health screening was lessened by sending everybody home. For those of you who are in industries where you have segments that can do telework, as the vaccine becomes more prevalent and you're trying to bring more people back into your workspace, the need for the health screening in the workspace is going to increase. So if you haven't had on-site health screening forms or protocols before now, you should get some. It's not too late. You still need them. If you have them, look at them. Because some of the questions we were asking back in April when we started putting these forms out, they need to be changed and they need to be updated. So do a little refresher on your forms. But the little boop where you walk in and they take your temperature, you could never do that before. That wasn't a thing. That would be illegal, right? So just keep that in mind. We're in a strange place right now. All right, so with respect to health screening, we obviously have a big new factor in play now, which is vaccination. And you're going to be having increasing numbers of your workforce who have been vaccinated. Can you ask people that? What do you say about that?
Yes, that one's pretty easy. You can ask your employees whether or not they've received the vaccine or not without sort of having a medical examination under the ADA. So there should be no issue with asking an employee if they've had the vaccine or requiring an employee to show you proof of receipt of a vaccine. That shouldn't be an issue. The only caveat to that would be if an employee says no, or I have not had it. Any kind of follow-up questions might elicit information about why they didn't give it. So you just want to be careful. It's a simple, have you had it, yes or no type question.
So if they say, no, I haven't had it because of my religion, or I haven't had it, then it raises the issues you addressed before. If they say I haven't had it because of a health issue, you're delving into a confidential ADA disclosure. And it depending on the circumstances, you need to be careful about pressing further with that. Is that right?
Right. You don't want information that you can't use or can't act on. It's just not helpful to you to have. So my advice would be it's sort of a yes or no. And sometimes we get questions from our clients about, can we make work assignments, on that basis? If an employee's been vaccinated, I'd feel more comfortable with them in the general public. Can I make an assignment on that? The answer is yes, but be sensitive again to if an employee who for a disability related reason or for a religious reason is unable or unwilling to get the vaccine, we don't want to create some sort of discrimination claim that they maybe didn't get that good assignment that the person who's vaccinated has. So just be sensitive to those sort of issues and look holistically at what you're doing with that information about vaccines.
And I think it matters the setting too. Like if you're in a industry where a client is having interface with the public, whether it's a healthcare situation or even otherwise, I think that's a really legitimate reason to restrict that person to a different kind of duty if they haven't been vaccinated, as long as you follow all the precautions and rules that Jen has outlined. But if it's more arbitrary than that, I would be careful. I think the idea of a segregated workforce of the people who've been vaccinated versus the people who haven't could be problematic, not just for morale, but I'm sure there's some legal theory we could tie to that. I was thinking about at the pediatrician's office, you put the sick people over here and the well people over here. Are we gonna have all the vaccinated people on this floor and the unvaccinated people down here? There's probably some people out there who are like, yeah, we would love to do that. But it raises a bit of a red flag to me for a lot of reasons. And I haven't developed my thoughts further on that topic. If any of you guys have, feel free to chime in. But we're going to be dealing with a mixed workforce for months now, right? All right, so let's switch topics a little. This is something I've dealt with a lot, and you guys probably have as well. During the pandemic, as we went through the evolution of that, we had a lot of people who needed to be accommodated. And the main accommodation, obviously, is working from home if telework is an option for that person. Some of those telework arrangements were done in a thoughtful way, and some of them weren't. And the reason they weren't is because it was just crazy and we were in a rush and we were trying to just keep everybody safe and get our work done. But that's been going on a while. And a lot of employers I work with have had people working from home for months and months. They're getting anxious to want to address those situations and to want to maybe bring those people back. What kind of considerations, Robin, do they need to be thinking about right now?
Okay, so speaking of working from home, I'm working from home today. And you may hear a doorbell ring because it's rang a couple of times in the last couple of minutes. So working from home is a challenge, but what's challenging for employers is trying to bring employees back into the workplace. And so like Kara, I have dealt with a number of clients who have struggled trying to return employees back to the workforce. And I think from the perspective of the employer, you really, when you're dealing with trying to return an employee back to the workforce, you have to go back to your interactive process in determining whether or not telework could be an accommodation. And what is it an accommodation for? It's an accommodation to allow the employee to perform the essential functions of their job. And so as you're traveling through that process, really you need to look at, is the employee able to perform the essential functions of their job at home? And a lot of these telework arrangements, you have employees who are performing some of their job, but they're not performing all of their jobs because we're in an emergency situation. And so they've been allowed or excused from some of the essential functions of their job. So consider that as the employer. And really, when you're looking at that and returning employees back to work, you really want to look at kind of where we are in the pandemic. What are the numbers? Is it reasonable to require the employee to come back in? And if it is, then you would want to begin that process of requesting for the employee to return to work. If they ask to telework due to their disability or their risk of exposure, then you would need to determine whether or not it would be appropriate for them to continue to telework, or whether it's necessary to provide other accommodations within the workplace that would provide some protection. And really for at-risk employees, depending on that other protection could be something as simple as giving them a staggered work time so that they are not entering or exiting when everyone else is coming in or out of work. Or if their position does not involve direct interfacing with employees in the work area, perhaps allowing them to have a workspace that is separated from other employees, so ensures that they don't come in contact with other employees. But for those employees that are teleworking and you're wanting to be back, what the EEOC has said, initially the EEOC, this is pre-pandemic, said that once you have employees demanding telework, where their essential functions of their job require interaction with coworkers or contractors, and that's important to manage them on site, that an employer doesn't have to give that telework as the option, because it would be an undue burden and they would not be able to perform the essential functions of their job. And really that would continue for an employer post-pandemic, where number one, the employee is not able to perform the essential functions of their job, or two, perhaps you as an employer have had performance issues with the employee and you were unable to address those employment issues while they're working remotely. And I think from an employer's perspective, it's important to document those in real time while the employee is working remotely, so that when you begin that discussion, those are factors that you can consider in determining whether or not that telework arrangement would be reasonable moving forward. But really, this is a minefield for employers, and it's something that employers have never had to deal with, because there is going to be an established track record of employees who now perhaps have worked from home for 11 or 12 months, and they won't be able to understand why they can't continue to do that moving forward. And so there are certain areas where I think it's very, very important for employers to kind of reach out and get legal advice on struggling through those issues. And in my opinion, this telework arrangement and returning employees to work post-pandemic is really going to be one of those that employers are going to have to tread very carefully, document a lot, and seek legal counsel.
So I think all that is great advice. There are a lot of practical concerns and morale issues mixed in with the legal landmines here. And for instance, a lot of people that have been allowed to work from home as an accommodation during the pandemic, they aren't disabled, and it wasn't because of a health reason, and it wasn't because of anything that we would be protected under current law. As a matter of fact, it's arguable whether even people in that age category would be. There's no other law. There's no law that allows people over a certain age to stay home. It was just the CDC guidance that they were susceptible that caused a lot of employers to let those people stay home. And I know for a fact there are a lot of situations where somebody was just fearful or uncomfortable, and because the employer was trying to do the right thing and stop the spread of this pandemic and create a less dense workspace, they let those people work from home, even though they don't have any disability or anything like that. And so, I think in looking at a phase back in process, if that's your goal, to get more people back in the office, which isn't everybody's goal, and we'll talk about that, but if that's your goal, I would start going through and saying which of these are legally protected accommodations under the ADA, and which of them are just things we were being nice to let people do. Because it's the ones that are legally protected that have more of the legal landmines that Robin was talking about. All of them are going to have the morale and the psychology issues.
There,
but you got to remember, why did we let this person work from home? And is this something where I need to worry about an ADA interactive process? Because not all of them are. And Robin, you raised a really good point too about work performance. Even if you're required to let someone work from home, if that's deemed to be a required accommodation under the ADA, that doesn't mean you have to let them work from home and be terrible and not do their job. You know, you can manage their performance, you can counsel them, you can require them to do the essential functions of their job at the required competency level. And I think there's been there was a lot of undermanagement of performance that went on during the early stages of the pandemic that have set some bad habits in place for everybody. And that's not true in all cases, but I think it's true in a lot of cases. Anyway, that's what I've been seeing. And my other comment that I would make here is this is a weird ADA accommodation interactive process situation, because usually in the normal times, in the before times, that has to do with an employee's impairment and a limit on functionality or an inability to do something where they can only do part of their job, or they're so sick or impaired they can't do their job at all and need time off. And so we're waiting to see if they improve, to see how long we need to continue to accommodate them, if it's reasonable. This isn't about, these are people that were walking around doing their jobs just fine before the pandemic. The reason that you're accommodating them is because it's related to the workspace and the public health, right? And so we're not waiting for anything about the employee to change. We're waiting to see if something in the work environment or the public health situation changes, to see if they can be required to come back. And that's just a different way of thinking about it. And in doing my interactive process and guiding clients through that, I've even started to, you know how we send job descriptions so that a doctor can say whether somebody can do their job or not. I've been starting to send the office layout and the COVID protocols and the workplace density numbers. Like, you're saying this person is at risk. Well, here's the current situation in our office space. And there's only 2 people on her floor, and we're doing staggered shifts, and she has an office where she can close the door, because the doctor might need to know that in making the decision. And I think the longer this goes on, employers are going to maybe want to push a little more on all that to make sure people really require the accommodations that are being asked for. Some may not want to go to all that trouble. Anybody disagree with any of that? Those are the things I think to myself. So it's nice to be able to have a group to bounce it off of.
Well, I agree. I think from a practical standpoint, kind of how do you bring employees back? So say it's a workforce that has been working remotely entirely, or a work group. I think the first step is just begin by, setting expectations with employees, just from a morale issue, and letting them know, okay, so as of this date, the expectation is that we're going to return to work. These are the safeguards that we have in place, and then put the onus on those employees if they believe that they are disabled and need an accommodation. And then at that point, you go by that fact specific, looking at each employee. But I think that to kind of set those expectations with the employees on what's expected, and giving them a little bit of time to kind of adjust their mindset after working from home for a long time. I think that hopefully will help kind of soften the blow a little bit.
Robin, what about the people we've let work from home because of childcare issues? Do we still have to do that? Should we still do that? And David, or Todd, I think is going to tell us a little bit more about the current status of the Family First Coronavirus Relief Act. But just from in the current situation, is that a required accommodation, or what do clients need to be thinking about?
So I can jump in and answer that if no one else wants
Sure.
to jump in. So under the current law, there is no requirement that an employer provide leave for childcare. And so, under the Families First Act, there was some protected leave that was measured, but that is no longer mandatory and would be voluntary. So,
But check state law. Just make sure that that's true.
That's a great point. So I will say this, I'm in Mississippi, and for those in Mississippi, we have very few state laws governing COVID, but that is true because our audience is
But Robin, what you said is still true. I think you've got to deal with the psychology of your workforce and the realities of their situation. So continuing to work with folks in that situation and giving them plenty of notice to kind of get their preparation together is a good idea, even if it's not legally required at this point. Okay, so let's switch gears again a little bit. We talked about the safety protocols we still need to keep doing in the workplace. And one of those is when you have a COVID exposure situation or a person who has COVID, you need to do some either isolation or quarantine protocols and some contact tracing and things of that nature. So David, can you tell us what is the current guidance on that?
Yeah, sure. And so technically you might want to mute your mic here. We're getting an echo. Yeah, technically the protocol that the CDC has laid out is to follow your local health board. But realistically, at least every local health board I've ever seen follows the exact CDC guidance. And so what we saw at the beginning of December was new guidance about the quarantine length. And as you probably know before, the CDC had a strict 14-day quarantine if you had exposure to somebody who has COVID. And we here at Butler Snow on this panel, our clients did quite a bit of grumbling about that, felt like that was quite lengthy. I think the CDC heard a lot of that grumbling as well. And in this new guidance that's now been lessened, and in lessening that, the CDC actually recognized both the economic burden of a 14-day quarantine as well as the negative impact of such a quarantine on the mental health of the individual's quarantine. And so based upon science, they've backed off of that. And the current state is that 14-day period has been reduced to 10 days if the employee is not tested at all, if the employee, and if the employee has no symptoms during all those days. If there is testing, COVID testing of the employee, that time period of the quarantine is even less, such that after day 7, the employee can return to work if the employee has had a negative test that was taken within the last 48 hours and if the employee has no symptoms. But under either of those options, whether it's day 10 or day 7, the employee is still required to monitor his or her symptoms through that entire 14-day period, number one. And then number two, the CDC has asked employers to counsel their employees to take mitigating measures such as social distancing, mask, hygiene, that kind of thing. So that's where we are. And, as we've said, the CDC guidelines are evolving. So it's one of these things you need to pay attention to because that might change within the next few weeks.
Those of you who have kept people in the office or who have essential workforces understand the true difficulty of doing this quarantine stuff. It's essential, but it's really hard to manage. And so for those of you wanting to bring people back from telework, you haven't had to worry so much about quarantine because everybody's been at home. So just keep in mind that once you bring people back, you have to deal with exposures, contact tracing, and sending them home for these periods of time. So you just want to take that into consideration as you decide when is the best time to start bringing people back. Definitely keep your eye on the evolving guidance. For those who have had COVID, the current CDC guidance is that if it's within 3 months of a positive test and you've recovered, you don't have to quarantine. So we're going to be dealing now with a mixed workforce of people that some of them have had COVID and some of them haven't had it. So if you have people that you know have tested positive and they crop up again, getting too close to somebody that you find out has COVID, you can take that into account, and they're in that safe space according to the CDC for 3 months where you don't have to send them home. And there may be a safe space beyond that, but the CDC hasn't been willing to say that yet. And that's a good question for Dr. Buddy Creech next week if you want to ask him where things stand on that. And somewhat related question, antibodies testing. So, some people have gotten those tests to see if they've ever had COVID and maybe had it and didn't know it. Are we allowed, Jen, to ask people if they've had antibodies tests or to disclose that or to get one?
So for better or worse, this is actually one of the questions that the EEOC has given a definitive answer to. But unfortunately, the answer is no. You cannot require an employee to take COVID antibody test. So obviously, I'm differentiating between a test for the live virus and an antibody test. But if you're asking about whether an employer can ask an employer to go get tested to see if the antibodies are present, the answer is no, they cannot do that. Now, if you want to, as part of your return to work, bring people back to work, have your employees regularly tested for COVID, the live virus, that is permissible. Again, for now, I think as our pandemic maybe hopefully starts to become less of a pandemic, the answer to that question may change, because the EEOC has always been very against any kind of testing or screening of a medical nature. So I think you want to keep your eyes open. You want to keep checking EEOC and CDC guidance, but for now, you can continue to test your employees for the presence of the live virus if that's something that you're inclined to do.
I think the EEOC or plaintiffs' counsel, when they're grappling with suing people over this stuff in the months to come, I think it would matter the setting. If you've got an essential workforce, like you're a public utility or a hospital, and you need to keep people out there, and so you're requiring everybody to regularly test, I see no problem with that. But if you're a business where you just want people back, like everybody's been teleworking and it's been going sort of fine, but you just want people back in the office, and making all of them go get tested twice a week so you can just see them in the office. As the situation evolves, I would be a little leery of that approach. All right, so we earlier mentioned the Family First Coronavirus Relief Act, which was a huge force in all of our lives for a big part of 2020, but which is expired now. But what is going on with that, Todd?
Yeah, so like everything that I've had to talk about today, Kara, this too is in a state of flux. So I've been the designated state of flux attorney. So back last March, Donald Trump signed the Families First Coronavirus Response Act, was created these various leave policies, expanding FMLA and providing childcare and so forth. And that was set to expire December 31. And as you all may have seen in the news, there was just a bit of drama toward the end of the year after the election. And one of the things that was being bannered about was whether or not additional relief packages would be passed that would possibly include extensions of the Family First Coronavirus Response Act. What ended up happening, Kara, is that basically the FFCRA died on the vine to a large extent, with the caveat that employers are encouraged by the Department of Labor, pursuant to a recently issued FAQ on their website, and that to voluntarily grant those types of leaves to employees. And they did expand the tax credit component through March 31. So it very well could be that additional legislation gets passed, before then, and certainly part of Biden's planned package going into the transition was to promote an enhanced extended FFCRA, to extend it through either through the fall, through September 30, 2021, or more likely, if it gets passed, through the remainder of 2021. Other proposals would include trying to lift the 500 employee cap coverage for private employers, and addressing or eliminating the exemptions for healthcare workers and first responders and so forth, and then expand leave to potential 14 weeks. So we'll see how all this plays out. But for right now, the short answer is that the mandatory leave requirements under the FFCRA are gone. Employers are encouraged to still provide them.
And they can still get the
DOLs.
tax credit if they do, right?
They can still get the tax credit through March 31. So we'll be following the news like the rest of you. But as soon as something comes out, if Congress actually passes something new, we'll be sure to alert everyone. So I would encourage everyone to frequent our coronavirus hub on our firm website, where we house all the up-to-date information on what's going on.
Yeah, thank you, Todd. It's a fast developing situation. The ones the employers that want to continue the voluntary leave, it's my understanding that you can do that and get the tax credit for it, but there's not an additional amount of leave available. It's the original amount that was granted under the law enacted in April. And so if an employer's already used all their leave, they don't get renewed leave as of January 1st or something like that. So you can give them leave now, but you're not going to get the tax credit for it if they've already used all the statutorily required leave, I believe.
That's right.
And David, did you have any other thoughts on any up and coming laws that clients need to look out for, assuming that our Congress has time and attention to devote to such things?
Sure, and Todd touched upon this. Again, if you don't mind hitting mute. And for those of you who don't know, those people who march on the Capitol.
He was the only one who tells me that I'm causing a problem. Thank you.
Okay. For those of you who don't know, the people who marched on the Capitol a couple of weeks ago did not retain control of the Capitol. So we do have a new president. We have a president now, President Biden, who has included as part of his America Rescue Plan a few aspects that would reinstate and extend the FFCRA through September 30th of this year. I don't like to get too detailed about proposed legislation because inevitably proposed legislation gets changed in Congress or not enacted at all, but I'll just give you a couple of brief bullets about this. It would provide 14 weeks paid leave, a max of $1,400 a week. Importantly, the previous exemptions would be eliminated such that, number one, instead of applying only to employers with 500 or more employees, it would apply to all employers regardless of size, but those less than 500 employees would be able to get reimbursed through a tax credit. And then secondly, there would not be exceptions like we had before for healthcare workers and first-time responders. It would apply to everybody. And so that's something to keep an eye out for. We also have seen Democrats pushing for COVID-specific OSHA standards. So you might want to keep an eye out on that. And of course, on the other side of the political spectrum, we have seen, particularly in state houses, Republicans, they are pushing for legislation that give liability protections to employers. So we can continue to monitor that, and we'll see more of the same on that front, I think.
One idea that I had for a future seminar is focusing on how some of these lawsuits have gone and turned out, and whether immunity defenses have been successful. I think we'll have enough water under the bridge, maybe in a few months, to do a survey to let you all know how that's looking. Robin, we've talked about some of the laws like the Family First Coronavirus Relief Act that are specific to COVID, or laws that might in the future be enacted but there are some laws already out there right now that may come in play that employers shouldn't forget about when they're dealing with pandemic workplace issues. We've already talked a lot about the ADA, for instance, which has been around forever, and we're just adapting it now to this purpose. What other laws do we need to just remember when we're working through these issues?
Well, Carrie, I'll first say you need to turn your thing on mute. So I'm kidding. I'm kidding. We'll call David Sheriff. He's the enforcer. So when it comes to employees not being able to work because they've contracted COVID or are sick, with the Families First Act now no longer being mandatory and the current status is nothing really applies. When you look at that, the only protected leave that employee could possibly have would be the FMLA. Now, as we all know, there is a tremendous range of symptoms and severity of illness. And so a lot of the more mild COVID illnesses may not rise to the level of requiring FMLA leave if the employee is unable it's really if the employee has a serious health condition and they're unable to work for 3 or more days and have required some medical treatment or continuing medical treatment. So when you look at that, that's really it quite possibly could touch on a large number of individuals who have been impacted by COVID, but maybe not all. When you look at those employees who aren't able to come to work due to childcare issues, like I said earlier, there's really not a whole lot of protection there. Now, Kara was very mindful about kind of the morale issues with childcare during the pandemic. But as far as those employees being covered by FMLA, they simply would not be. But think, for instance, if an employee has a child who is ill with COVID and the employee needs to stay home and care for that child, there very well could be an FMLA piece to that. So employers should be mindful that just because the Families First Act is no longer mandatory, there are other laws that impact that leave.
All right, and if you're in Mississippi or Tennessee or Alabama, like a lot of our audience, there really isn't too much in the way of state law that would change anything that Robin said. If you're in California or if in New York, if you're in some other states that have enacted mandatory sick leave laws, you just need to make sure you're aware of how those state and local laws, might come into play in these situations. All right, so we talked about kind of the idea of bringing people back to work, and it's not going to happen magically January 1st. We already see that. It's not going to, I hate to tell you, it's not going to automatically happen February 1st or March 1st either. But some clients have decided they kind of like the telework situation, and they're going to stick with it, at least for portions of their workforce, maybe permanently. Because people like it. Some people are productive during it. It certainly saves the need to pay for space and things of that nature. So if you're considering doing that, there are some things to keep in mind. And I wanted to just touch on a few of those as we head toward the close here. Can you require people to do permanent telework? Can you tell somebody that was hired to work in an office or a space to say, no, you're not working there anymore, you're working from home? The answer is, in an employment at will situation, yes, you can. You can change the terms and conditions of employment if you wish. You should be mindful of any kind of contractual commitment that would alter that, whether it's a contract individually with that employee or a collective bargaining agreement. But absent those considerations, you can do that. And I think then the question is, if you do that, how do you manage that situation and what are the legal considerations that you think about? And they're really not any different than from before the pandemic. We did have lots of employers that were doing telework arrangements full-time or part-time before the pandemic. And they honestly had a leg up on all this because they already had seen the problems and worked through them and put together good policies to cover telework. So everybody else is going to need to catch up with that. You need to look at the wage and hour ramifications, particularly for your non-exempt workforce, if you're going to keep them on telework. Time on and off the clock, it's very strange and fluid in those situations. And so you need to be sure you're giving crystal clear instructions on that and accurately reporting work time. You need to be sure you have people able to access your policies and that you're meeting the posting requirements under state and federal law. And in fact, I saw that the Department of Labor put out guidance on remote and hybrid workplace postings just a couple days ago. And I'm going to put that in the materials that are available for you all. You need to be mindful of security issues, Hipaa issues for people that are interacting with personal health information as part of their job duties, confidential client information, financial information of the business. Again, I think the transition to telework was done rather hastily for understandable reasons, without being mindful to a lot of these things. And as we settle in to continue telework through the remainder of the pandemic, and certainly if you're going to switch to that as the permanent mode of work, you need to give some careful consideration to that, including, I think, some particularized training and protocols surrounding HIPAA protected information and secure information in the employee's home workspace. I recommend telework agreements. I think that is a good way to lay out the expectations and the requirements of a telework position in a way that's clear to the employee and that you can reference. And managing the situation. We could do a whole 90-minute topic just on how to adapt your supervision and your workplace performance protocols and getting people engaged and getting people excited about work in a telework situation. That's a huge issue for clients. And it ties in with the legal issues because people who aren't happy and are struggling may have to be exited. And when you exit people, that's where your biggest legal exposure is going to arise if they say that you haven't worked with them sufficiently based on all these considerations that we've talked about. So, but a telework agreement can go a long way to sort of putting the expectations out there clearly. And again, it's never too late. If you haven't been managing your telework situations well up until now, you can start now. Just say, look, you know, we've been assessing how this is going, and we think there needs to be some more guidance. We want to make sure everybody knows what the rules are and what's expected, and start now. So just, and the wage and hour piece as well needs to be kept in mind. All right, so the final topic I wanted to talk about, and you guys can all chime in, I think we know the answer. You're still going to have people that don't want to come back. Even if, I mean, I can envision people even who've been vaccinated that don't want to come back, or of course the people that didn't want to get vaccinated or who haven't been able to. And last I heard, the young healthy people aren't getting vaccinated till like August or something. So we got a long time to deal with this. If I just don't want to come in because I'm uncomfortable and fearful, do you have to let me stay home? Thumbs up for yes, thumbs down for no. What does the panel say? Do you have to let me stay home? No, you don't. No, you don't. But I think we've talked through a lot of issues today where we understand that forcing people to do something they are psychologically uncomfortable to do can lead to consequences that are not good for your organization. Because if you're forcing someone to do something they don't want to do, and particularly then if you exit them from the organization, if they refuse, they can start to remember things like that, the fact you never offered them leave under the Family First Act, and you never had your post-op when you were supposed to, or you didn't do a fully compliant interactive process with them, or they've been working off the clock without, getting paid. They start, an exit situation triggers a lot of reflection from the person and from the person's lawyer, if they go to a lawyer or if they go to the EEOC, right? And then the other issue before we close is, if you haven't done everything you can do to make your workplace safe so that you can say this person's unreasonable and wanting to come back, you could be dealing with an OSHA issue or a retaliatory discharge claim under OSHA or under a variety of laws that protect people who voice complaints or grievances or concerns about illegal conduct or workplace safety issues. So before you dismiss someone's fears, you need to make sure you've really done everything you can to address those fears, and you're asking them to come back to a truly safe work environment. And did anybody else have any thoughts on that? No thoughts? We're exactly at 3 o'clock, so we're done. Thank you guys. I've learned a lot just listening to you all talk. These are very smart lawyers. Their contact information is available for you. A lot of you in the audience are clients that we work with all the time. So reach out to your favorite lawyer at Butler Snow, and we can help you kind of get into the nitty-gritty on your specific issues. I hope this has been helpful. Go to Buddy Creech's webinar on February 4th for more information on the vaccine. And if you want the written materials as they become available, just let us know and we will send those to you. All right, thank you so much for attending today. Thank you, everybody. Have a good rest of the day.